In this video, we are going to learn Act to override memorandum, articles, etc. This is the Section 6 of Companies Act 2013. The provisions of this Act shall have overriding effect to the provisions contained in memorandum of company, articles of company, and any agreement executed by it, and any resolution passed by the company in general meeting or by its board of directors, whether the same be registered, executed, or passed, as the case may be. Here we can say that register, executed, or pass, as the case may be, before or after commencement of this act. So here the thing that we need to understand over here, that the act has a mm, superiority when it comes to the effect of the act over MoA or AoA or any agreement executed by it, and any resolution passed by the company in general meeting or by its board of directors. So here, where the same may be registered, executed, or pass, as the case may be, before or after commencement of this act. So even if register, pass, or executed before the commencement of this act, same section will be applicable for that one. Okay, now any provision contained in the memorandum, articles, agreement, or resolution, memorandum, articles, agreement, or resolution to the extent in conflict to the provisions of the Act shall be void. Section 123 or 123 declares that no dividend shall be paid by a company except out of profit. The force of this section cannot be undone by any provision in the Articles of Association, because the articles cannot sanction something which is forbidden by the Act or MoA. Even still it attempts, then shall be void. This section starts with saving clause, save as otherwise. Here they have mentioned this section has been start with the saving clause, that is, save as otherwise, means if any other section of the Act says that provisions contained in the memorandum, articles, and agreement or resolution is superior, then we will treat it accordingly. Means in the Act, if any section precisely expressly saying that the article or agreement or resolution is superior, then we will treat it accordingly. Okay. Now, for example, Section 47 regarding voting rights of the members or shareholders of the Act deals with the voting power of members. A notification dated on 5th June 2015 says that Section 47 is applicable to a private company subject to its article of association. Now, if AoA of a private company says that Section 47 is not applicable to it, then in this case, AoA will become superior and Section 47 of the Act will not be applicable. Now we will start Section 10, that's the effects of memorandum and articles. Subsection 1 to Section 10 aims to impart contractual force to the memorandum and articles. It provides when the memorandum and articles got registered, it shall bind the members to the company, company to the members, and members to the member to observe all the provisions of the memorandum and of the articles as signatory thereof. Example, member to the company. The Articles of Association of Steel Bros and Company Limited contain clauses to the effect that on the bankruptcy of a member, his shares would be sold to a person at a price fixed by the directors. Woodland, a shareholder, was adjudicated bankrupt, and his trustee in bankruptcy claimed that he, Borland, was not bound by these provisions and should be at liberty to sell the shares at their true value. But it was held that contracts contained in the Articles of Association is one of the original incidents of the shares. Shares having been purchased on those terms and conditions, it is impossible to say that those terms and conditions are not observed. Example, company to the member. The articles of Odessa Waterworks Company provided that the articles may, with the sanction of the company at a general meeting, the directors may, with the sanction of the company at general meeting, declare dividend to be paid to the members. Instead of paying the dividend in cash to the shareholders, a resolution was passed to give them a debenture bonds. In an action by Mr. Wood, a member to restrain the directors from acting on the resolution, it was held that the question is whether that which is proposed to be done in the present case is in accordance with the articles of association of the company. Those articles provide that the directors may, with the sanction of the general meeting, or declare a dividend to be paid to shareholders. Prima facie, that means to be paid in cash, and the debenture bonds proposed to be issued are not a payment in cash. So it is Wood versus Odessa Waterworks Company. Example, member to member. Rayfield was a shareholder in a company. Clause 11 of the Articles of Company required him to inform the directors of his intention to transfer his shares in the company, and which provided that the directors will take the said shares equally between them at a fair value. In accordance with the provision, Mr. Rayfield so notified the directors, who are the members as well, who contended that they were not bound to take or pay for shares. So they said articles could not impose such obligation upon them in their capacity as the directors. Their argument was set aside by the court by treating those directors as the members. Accordingly, the directors, being members, were compelled to take Mr. Rayfield's shares at a fair value. It is in the Rayfield versus Hands in the case study. Okay, now students are advised to take note. Articles bind the members to the company and the company to the members, but neither of them is bound to an outsider. To give effect to other articles, no article can constitute a contract between the company and a third person. The articles of association of a company, La Trinidad, contained a clause to the effect that Brown should be a director and should not be removable till after 1888. He was, however, removed earlier and had brought an attention to restrain the company from excluding him. It was held that there was no contract between Brown and the company. Now, no outsider can impose articles against the company even if they purport to give him certain rights. Further, subsection 2 to section 10 provides all monies payable by any member to the company under the memorandum or article shall be a date due from him to the company. A company can recover causing area from a member as forcefully as it is recovering loan due. Now, now we will see the important section, two important sections. Those are alteration of memorandum, section 13, and alteration of article, section 14. Alteration of memorandum, procedure of alteration of memorandum. In order to alter the memorandum, the alteration includes the making of addition, omission, substitution, addition, omission, and substitution. Section 13 of the Act, along with rules 29 to 32 of the Companies Incorporation Rules 2014, provide the provisions that deals with the alteration of the memorandum detailed below. Alteration by special resolution, subsection 1 of section 13. Company may alter the provisions of its memorandum with the approval of the members by special resolution. Further, as per section 13(6), clause E, section 13, subsection 6, clause A, a company shall file with the registrar such special resolution. Name change of the company. So we already know that the first clause in the memorandum is a name clause, and if you want to change it, then we have to use subsection 2 and 3 of section 13, alteration of memorandum. Okay, so here we will change the name of the company. As per subsection 1, any change in the name of a company shall be effected only with the approval of the central government. Power delegated to ROC by central government in this behalf. Now, in writing in form number INC 24 along with P. So if the company want to change its name, then it has to get the approval of central government, and central government has delegated this power to ROC, and if the company had to in writings apply to the ROC for change of the name of the company in form number INC 24. However, no such approval shall be necessary where the change is in the name of the company is only the addition or deletion of the word private on the conversion of any one class of the companies to another class in accordance with the provision of the Act. So here it is clear that there is no need of such a central government approval, which is delegated to ROC, in case if the company has converted from one form to another form, or like, and it's adding its suffix like private or private limited or public limited. In this case, there is no need for such approval. The change of the name shall not be allowed to a company which has not filed annual returns or financial statement due for filing with registrar, or which has failed to pay or repay mature deposits or debentures or interest thereon. Once the necessary documents fill or file or payment or repayment made, then change shall be allowed. As per clause B, subsection 6 of section 13, the approval from the central government shall be filed with registrar by the company. Practically, importance of provision is deeming as a power of central government is already delegated to ROC. Okay. Further, as per subsection 2, on any change in the name of the company, the registrar shall enter the new name in the register of companies in place of the old name, and issue the fresh certificate of incorporation in form number 25. So we have applied in form number INC 23, and we get the new certificate of incorporation in form number INC 25. The first certificate of incorporation we got in the form number INC 11. But when we change the name of the company, then we get the new certificate, the fresh certificate of incorporation in form number INC 25 in case of change of name of the company. Now, with the new name, and the change in the name shall be complete and effective only on the issue of such a certificate. For example, Tata Sky, now it is Tata Play. Previously it was Tata Sky Limited. To change its name to Tata Play Limited, and this is its CI number, not other. Industrial Insight. On August 24, 1910, a company was registered in India under the name Imperial Tobacco Company, ITC Company, Imperial Tobacco Company of India Limited. As the company's ownership progressively Indianized, the name of the company was changed to India Tobacco Company Limited in 1970, and then to I.T.C as ITC Limited in 1974, in recognition of the ITC's multi-business portfolio encompassing a wide range of businesses. The full stops in the company's name were removed effective September 18, 2001, means in September 2001, it became ITC Limited. In 1974, it was I.T.C Limited, but now the full stop has been removed. Now it become ITC Limited effective from September 18, 2001. The company now stands restriction ITC Limited, where ITC is today no longer an acronym and initialized form. Okay, now students are advised to note that even if a company has to rectify its name under Section 16, this is voluntary change in the name. But in Section 16, there is a need of rectification, which we'll learn later on. Then also, nothing shall prevent such company from subsequently changing its name in accordance with the provision of section. Even if Rectify compulsorily change the name as per under section 16, then it can subsequently rectify, or sorry, it change its name in accordance with the section 13 alteration of memorandum first section. Okay, now first subsection. Now, rectification of name of the company. So section 16 is all about rectification of name of the company, where central government power of central government under this section conferred delegated upon regional director. Now, when you have to change the name of the company voluntarily under section 13 of the Companies Act 2013, there is the power, the approval was needed, and that approval is needed, and this power central government delegated to ROC, but when in case of section 16, where there is a rectification case, rectification of name is the case, then in that case, in that scenario, the central government delegated such power to regional directors by section 458 of the act, and is of opinion that the name original or revised new of company is identical with or too nearly resembles to the name by which a company in existence. So if regional director, in the knowledge of regional director, it comes that the current name of the company is identical or too nearly resemble to the name of the another company registered under the Companies Act or any previous company law in existence, then on its own or on an application by a proprietor of already registered trademark under the Trademark Act 1999, then it may direct the company to change its name. And basically, in as per section 13, there needs to be passed the special resolution to change the name of the company. But if the company shall change its name or but in case of rectification, the regional director may direct the company to change its name. The company shall change its name or new name, as the case may be, within a period of 3 months from the issue of such direction, after adopting an ordinary resolution for the purpose. Note, application by a proprietor of registered trademark shall be made within 3 years of the incorporation or registration of 3 years of incorporation or registration or change of the name of the company. Further, the company, after changing its name or obtains a new name, shall give notice of the change to the registrar along with the order of the central government regional directors within a period of 15 days from the date of such change. So, if the company, after changing its name or obtain a new name, shall give notice of the change to the registrar, because the power is with regional director. So, regional director give the direction to the company to changes to rectify its name. Once it passed ordinary within the 3 months of period, but after such direction has been given to the company, then once the company had changed its name, then the new name it has to submit it to the ROC, and the change to the registrar along with the order of the central government. That if he has to attach the order of the central government, that is of the regional director, within a period of 15 days. Once it has changed the name, within the period of 15 days, it has to submit. And from the date of such change, it has to submit it to the ROC that I have changed the name. And please issue the new certificate of incorporation. And registrar, on receipt of notice, shall carry out the necessary changes in the certificate of incorporation and memorandum. And if a company is in default in complying, uh, if a company is default in complying with any direction given under subsection 1, then the central government shall allot a new name to the company in such a manner as may be prescribed, and the registrar shall enter the new name in the register of the company in place of the old name and issue a fresh certificate of incorporation with a name which the company shall use thereafter. Now, provided that nothing in the subsection shall prevent a company from subsequently changing its name in accordance with the provision of section 13. Now, we will see change in the registered office.